In March 2023, Italy shut down ChatGPT. Not slowed it down, not issued a warning. It was shut down. The Italian Data Protection Authority, the Garanti, pulled the plug on the most talked about technology product on the planet. Overnight, 60 million Italians lost access. OpenAI, valued at tens of billions of dollars, was blocked from an entire European country. The reason? They never conducted a DPIA or Data Protection Impact Assessment. One missing document, one skipped process, and one product banned from a G7 nation. Now here's what most people don't realize. A DPIA has been a legal requirement under GDPR since 2018. That's over 6 years. And yet, in a recent survey, fewer than 35% of professionals said their organization conducts DPIAs consistently before launching new projects. Most either skip it, do it after the system is live, which defeats the purpose, or produce a document that wouldn't survive regulatory scrutiny. And here's what's changed. The EU AI Act is now in force. It requires AI-specific impact assessments for any system classified as high risk. These AI assessments layer directly on top of GDPR DPIAs. If you are already behind, you are now doubly exposed. In the next 5 minutes, I'm going to show you exactly how to conduct a DPIA, step by step, that identifies risks and satisfies regulators. Every major tech company that operates in Europe conducts them for any new product. They do this because they've seen the consequences. Meta was fined 1.2 billion euros in 2023 for violations a proper DPIA would have flagged. Amazon was fined 746 million euros. TikTok was fined 345 million, all for failures in assessing data risks. Regulatory authorities have all stated that the absence of a DPA is itself a GDPR violation. You don't even need a data breach to be non-compliant. Increasingly, DPIAs are a condition of doing business. Procurement teams now ask for DPA evidence. If you can't produce one, you lose the deal. All right, here's the framework. 6 steps. I'll walk through each one with a real example, an insurance company deploying an AI fraud detection system. Step 1, the screening test. Do you even need a DPIA? If your project meets 2 or more of the EDPB's 9 criteria, it's mandatory. Number 1, evaluation or scoring. 2, automated decision-making with legal effects. 3, systematic monitoring. 4, processing sensitive data like health or biometrics. 5, large scale. 6, matching datasets. 7, vulnerable individuals. 8, innovative technology. 9, processing that prevents exercising a right. Our insurance company's AI system triggers 4 of these. It makes automated decisions, uses health data, operates at large scale, and evaluates scores. Mandatory. Step 2 is describing the processing. This is where regulators judge your seriousness. You need to document 8 specific things. 1, what personal data is collected? 2, from whom? 3, how's it collected? 4, what is the purpose? 5, legal basis. 6, retention period. 7, who has access? 8, international data transfers. Our insurance company documents 200,000 claimants' health records. Legal basis is legitimate interest. Data is shared with a US-based AI vendor. Be honest. Step 3, necessity and proportionality. You must demonstrate that you actually need this data and you're not collecting more than necessary. Is it genuinely necessary? Could the same purpose be achieved with less data? Are safeguards like encryption in place? Can people exercise their rights? The insurance AI originally auto-denied claims. The DPIA flags this as disproportionate. The mitigation can be, all denials must include human review first. Step 4, identify risks to individuals. Remember, assess risks to the people, not the company. That is a fundamentally different perspective. Document unauthorized access, inaccuracy in decisions, data loss, and unwanted processing that people didn't expect. Also assess discrimination or bias, loss of individual control, and the possibility of re-identification from anonymized data. Our insurance company identifies 5 key risks, scoring each for likelihood and severity. A breach exposing health records is high-severity impact. Step 5, define mitigation. For every risk, define measures to reduce it. These fall into technical, organizational, and contractual categories. Technical means encryption and logging. Organizational means training and audits. Contractual means standard clauses with your vendors. Then make the call. If residual risk is acceptable, sign off. If high, you must consult regulators. If it can't be mitigated, don't proceed. Finally, step 6, keep it alive. A DPIA is a living document. It must be reviewed whenever the processing changes or at minimum annually. To summarize, screening, description, necessity, risks, mitigation, and review. Build it into your calendar. There are 3 mistakes you need to avoid. 1, doing it after the system is live. 2, assessing risk to the company, not individuals. 3, never updating it. Head over to grctimes.com to download our free DPIA template and best practices guide. If you want more practical GRC skills, subscribe to this channel.